responses and assign responsibilities and so on. Over to you. So you have the floor, Ambassador.
Thank you very much, Mr. Chairperson. Mr. Saif, please begin.
I wish to thank the distinguished committee members for giving me the opportunity to present our major activities in economic development for the Arab population and to respond to some of the questions of the members. The development and integration of the Arab population is one of the economical priorities of the Israeli government. In recent years, the government approved several resolutions dedicated to that purpose, with a budget that amounted to 5 billion Israeli shekel, which is about 1.4 billion US dollars. However, despite these investments, gaps still remain between Arabs and Jews in Israel, and more needs to be done. The Authority for Economic Development of the Arab, Druze, and Circassian population in the Prime Minister's office, which I direct, was established according to the government resolution 1204 in 2007. It currently runs a budget of over 2.4 billion Israeli shekel, which is about $700 million of governmental resolution and program dedicated to the economic development of the Arab population in several main fields. The authority is an integral part of the Prime Minister's office, those from one hand having a direct connection to the government, having an influence over socio-economical decision-making process and government resolution, and on the other hand is connected to the field, municipalities, businesses, and civil society. Governmental resolution hereinafter are several details regarding the government resolution for the benefit of the Arab population. The 5-year plan for the Arab population on March 2010, the government approved resolution number 1539, titled 5-Year Plan for Economic Development of Minority Localities. According to this resolution, the plan focused on the development of the economy, increasing employment, enhancing housing and real estate, providing transportation, and ensuring personal safety and enforcement in 13 chosen localities encompassing 25% of the Arab population in Israel. The budget for the implementation of this plan is about 778 million shekels, more than 2010 million US dollars. The resolution is already almost fully implemented with 90% implementation rate. Another major governmental resolution in January 2012, the government approved resolution number 4193, in which is decided to further advance the integration of Arab population within the labor force, with an emphasis on a woman. And I'm commenting here, responding to one of the comments of the members regarding the employment of Arab women. The budget for the implementation of this plan is 730 million shekel, which is about 208 million US dollar. And as of 2014, over 93% of this resolution annual budget was already implemented. Now I wish to present a few topics that we are currently working to promote, starting with employment. In recent decades, the integration of Arab population in the labor market increased steadily, including entry into new fields of employment and achieving higher education. However, gaps still remain, among others due to difficulties in finding employment in the Arab population, difficulties in finding jobs in advanced fields of employment, and due to geographical dispersion of the Arab population, 2/3 of which resides in the north of Israel, in small localities where the range of employment possibilities is limited. Following a professional examination, the government decided to set the following goals for employment in the Arab population: 42% employment rate among women and 78% among men by the year 2020. In the year 2010, the rates were 24.6% for women and 65% for men. Currently, 2013, the rates are 27.7% for Arab women and 70% for Arab men. Major employment projects: the establishment of career centers in Arab localities, the authority with the Ministry of Economy, the Jewish Joint, is in the process of establishing 21 career centers aimed at providing employment services to unemployed persons of the Arab population. These centers will operate as one-stop shop for employment. 17 centers are already running, and in 2013, they provided new jobs placement for over 3,000 persons. Industrial areas. In the frame of a number of governmental resolutions, among them Resolution 1539 and 4193, a sum of over 400 million shekel was allocated to the development of industrial area in Arab localities, and among other things for the transfer of businesses from residential area into these industrial zones. Regarding higher education, and it was a question about the higher education of the Arab population. The Arab population in Israel constitutes approximately 20% of Israel's population and about 26% of the age group relevant to higher education. In recent years, the rate of Arab students among the total students studying for their first degree is slowly increasing. According to the figure of the Council for Higher Education, in 2013, the rate of Arab students studying in a university stood at 14%, compared to 11% in 2010 and 7.6% in 2007. An increase in the rate of Arab with academic degree in the year 2005, the rate of Arab with academic degree was about 8% for Arab women and 10% for Arab men. And in 2013, this rate increased to 13% for Arab women and 12% for Arab men, but still the gaps with the Jewish sector are large. In January 2010, the Prime Minister's Office and the Planning and Budgeting Committee of the Council for Higher Education has set a multi-year plan for the years 2011 and 2016 with the goal of lifting barriers and making the higher education system more accessible for the minority population. The authority of the committee and the Minister of Finance has allocated a budget of over 305 million shekels, which is about $85 million for this purpose. Irtika Scholarship. In 2014, the Prime Minister's Office with the PBC has created the Irtika Scholarship that provides special scholarship designated for the Arab population. This fund supports first-degree students according to their socioeconomic situation and field of study. In 2013-2014, 650 students received such scholarship, of which 52% were women. 650 more will receive the scholarship this year, amounting to 25,000 shekel per the 3-year scholarship. Regarding the public transportation that was also raised by one of the members, both the authority and the Minister of Transportation and Road Safety see great importance in expanding the accessibility options for the Arab population in Israel, since it allows this population to reach, among other things, employment, education, and education. Since 2006, the Minister of Transportation has invested great funds in development of transportation solution for the Arab localities. This is evident, among other things, by an increase in the number of bus rides, the number of stops and destination, and the total route length, and more. For example, in 2005, only 81 of 157 Arab localities received such services, with 3,600 bus rides a day. In 2011, this figure increased by 53% to 5,655 rides a day. Regarding the planning and housing in Arab localities, the Minister of Interior has promoted updated outline plans to 83 Arab localities, and it is expected that in the next 2 years, all the outline plans that are under statutory approval procedure will be completed. The rest of the plans are promoted by the local authorities and local councils. Detailed plans, over 50,000 new residential units on private and state land are in planning procedure. In the last 3 years, over 1,000 housing units were marketed in the Arab localities. Despite these positive changes, there is much to be done and further action are to be taken. Thank you. I'm transferring to Nadim Aboud.
Ladies and gentlemen, in the light of the questions put to us by the distinguished members of the committee, I will talk about the integration of the Arab community in the government. The Israeli government and the Israeli Ministry of Justice makes effort to include the Arab population in the civil service as they reflect the multicultural nature of the Israeli society. The Arab population constitute 20% of Israel population and are an important economic force. And the integration of educated Arabs is beneficial to the economic situation of the Arab localities. As of April 2014, the number of Arab staff amounted to 8.82% of the Israeli civil service, compared with the percentage in 2007, which was at 6.17%. Their number amounts to 6,451 staff members out of 73,000, which represents an increase of 1,469. That is 26.6% within 2 years. As I said before, the Ministry of Justice finds it extremely important to integrate Arab men and women in the labor market. Among the many actions taken, on the 30th of September 2014, a national convention was held in Haifa in order to integrate Arabs in Israel in the Ministry of Justice. This convention included a number of various lawyers and people with academic achievements, Muslims, Christians, Druze, and Circassians. The Minister of Justice participated in the convention, including the Director General of the Ministry of Justice, a number of directors of divisions, the General Prosecutor. The Ministry of Justice, in fact, is attempting to employ Arab in order and to encourage the private market and the private sector to employ Arabs. A number of workshops during this convention were organized in order to to provide training on how to write a CV, to prepare for interviews. A short film was also shown showing a number of Arab staff members relating and talking about their experience. The Ministry of Justice hopes that this convention will be fruitful and will contribute to expanding the representation of Arabs in the various divisions of the Ministry of Justice. I would now like to refer to another category of the Israeli population, which is the category of women and their representation in the Public Prosecutor's Office and the Ministry of Justice. There are 617 prosecutors and more than 51% are women. There is an increase in female justice, including an increase in the number of judges. As of August 2014, the number of female justice is 49.9%. Compared to 2008. In the High Court of Justice, there are 3 female justices out of 14. The clerk is also a woman. In central courts, there are 72 female justices out of 177. And in the reconciliation courts, there are 236 judges out of 426. And there's also an increase in the number of Arab justices. As of August 2014, there were 14 justices and 7 female justices. Christians, 18 judges and 9 female judges who are Muslims, and 7 Druze judges. Thank you.
Ms. Palmore.
Of our committee members. First of all, I'll say a few things about women in politics. Your request to have a women prime minister has already been texted to my minister, Mrs. Tzipi Livni, and we will take care of it personally. But this is a good opportunity to mention that in this Knesset, the 19th Knesset, the rate of women who are members of the Knesset has increased from 19% to 22.5%. We have 27 women nowadays. 33, the 33rd government has also increased with a rate of women ministers. We have a woman who is a Minister of Health. We have the Minister of Justice, the Minister of Culture, and the Minister of Immigrant Absorption. So this is from the political point of view of women. The integration of women in the civil service is also something that we can be proud of. In 2013, of the 60,971 civil service employees, 65% were women. The rate of women employees holding first and second academic degrees is higher than men, although the rate of men employees holding a PhD degree is higher than women. In addition, 48% of the top 4 ranking positions and 46% of the top 3 ranking positions were held by women. I would like also to address to the issue of women's segregation in the public sphere, which is a painful issue indeed. Following several cases in 2011 in which it became known that women had been segregated in public transportation, cemeteries, ultra-Orthodox radio station, and other spheres, an interministerial team chaired by the Minister of Culture and Sports was established. In addition, a professional team was established in the Ministry of Justice to examine the phenomenon as well as ways to confront it. The team, which is headed in the Ministry of Justice by the Attorney General, decided to adopt recommendations regarding prohibition of women's segregation and to promote criminal legislation that will prohibit harassment of a person in a way of contempt or humiliation for reasons of religion or religious group, nationality, country of origin, gender, sexual inclination, opinion, political affiliation, personal status, or parenting. All of the above with the purpose of preventing access and use of a public service or with the purpose of harming the conditions of receiving such a public service. It was concluded that a draft bill will be presented in the near future. The Ministry of Justice has further drafted an amendment to the prohibition of discrimination in products, services, and entry into places of entertainment and public places, according to which segregation of women constitute a criminal offense punishable by law. The legislative process in this matter is underway. I did not know if I can answer your question whether somebody has been indicted for these offenses yet, but we will check that, and if we will have an answer later on, we will give an answer for that as well. Government resolution number 1526 of March 30, 2014 declared that the segregation of women constituted a serious phenomenon that is characterized by the discrimination of women as such, and which require affirmative government action in order to eradicate it. The authority has disseminated this resolution to all majors and chairpersons of local authorities, demanding that they ensure that the segregation of women do not occur in ceremonies, public events, funerals, public transportation, or any other places in the public spheres. On March 31st, 2014, the Ministry of Justice published its first report, according to which progress was made in the field of prevention of women's segregation in all examined areas. The relevant ministers were instructed to issue a progress report on this matter within 90 days, and the reports were presented on schedule. In addition, the government resolution number 4052 of December 29, 2011, the government resolved that the authority will operate an open hotline designated for receiving complaints concerning women's segregation. On January 8, 2012, the authority published the opening of this hotline. According to information received from the authority, the complaints that were received were handled with the relevant authorities in each case. According to this resolution, the Ministry of Transportation, National Infrastructures, and Road Safety has also opened such a hotline designated for complaints regarding women's segregation in public transportation. And now your surprising question about freedom of divorce in Israel, of women in Israel. I mentioned the fact that I've been nominated as the first woman to head the rabbinical courts, which is new to me. It's only 2 months, and it's a temporary mission. But I would like to say that it is a very difficult reality in Israel. The Jewish laws indeed demand the consent of both the man and the woman for divorce, and we are trying to deal with this issue in the best ways we can. It's not you know, I assume that everybody knows that when it has to do with religion, it should be treated in a very delicate manner. But I was surprised and happy to see that you watched this important movie about the story of Vivian Amsalem, which is indeed, it's a fiction movie, but indeed it is the story of many women in Israel. The last issue that I would like to mention is the memory of Holocaust. I was happy to hear this issue raised by one of the committee members. I am myself the daughter of 2 Holocaust survivors. We teach the memory of Holocaust throughout all of the school years. Last year, the Minister of Education suggested that we will start in the kindergarten, and there was a lot of controversial discussion in Israel whether we should start so early. But we teach these issues. It's part of our history. We have museums that commemorate the Holocaust. We send missions of youngsters to visit Poland and learn about the Holocaust. In these missions, we have youngsters from all the Israeli society, not only Jewish youngsters. And we believe that learning about the Holocaust is also an opportunity to learn about human rights, about rights of minorities, about difficulties of being a minority, wherever that is, and to make sure that this will not happen again all over the world, not only to the Jewish people. So we are definitely committed to that issue and to the memory of that issue. So we appreciate this question, and now I will pass it to my colleague, Dr. Shindorf.
Thank you very much, Director General Palmore. My name is Roy Shendorf. I'm the Deputy Attorney General for International Law. And in the past year, since I've been appointed in October 2013, I'm also heading the interagency team for the review and implementation of the recommendations of the Human Rights Committees, including this distinguished committee. I'm very pleased to be here, first and foremost, to provide this committee information that is necessary to the work of the committee and to its fulfillment of its tasks, but not less in order to be able to hear from the members of the committee their questions and comments that are extremely helpful to me in fulfilling the responsibility that I've been tasked with to review and implement the recommendations of of this committee. Mr. Kailin, you've asked if I could provide a number of examples of issues that have been addressed by the interagency team. I will briefly do that. I will mostly address things that have been, or I don't want to claim credit for things that I have not done personally. All the things that I will describe are things that have been done by my predecessor in this position, but I can assure you there are many other things that we're currently working on, and I hope that once we actually implement them, we will be able to report to this committee. But to give a few examples, one example is the issue of education in the Ofer prison in the West Bank, for example. So as part of the preparation of the Israeli delegation to the dialogue with the CESCR committee in 2011, it was found that an NGO shadow report asserted the Israeli prison service does not operate classrooms for minors that are detained in the Ofer prison. This issue was brought to the attention of the interministerial team, and after deliberations, the situation was rectified, and today the Ofer facility operates 2 school classrooms for minor security prisoners. Another example I can provide is amendment number 27 to the security provisions order in the West Bank. This amendment canceled the possibility to prevent a meeting between a detainee suspected of severe security offenses and his or her lawyers, even after the end of the term in which such a meeting may be prevented in the West Bank under the law of belligerent occupation. The issue was discussed and promoted in the joint team by and large due to a report by the Public Committee Against Torture in Israel in a periodic report which claimed which raised claims or concerns regarding prevention of meetings of lawyers with detainees in the West Bank. Another example would be the raising of the age of criminal responsibility in the military courts in the West Bank. I think this committee has also addressed the issue in the past. The age of a minority was 16, and youngsters above the age of 16 were considered adults. This was rectified also partly by an effort of this interagency team, and today the age of minority is 18. And there are other examples. I will mention one. I assume I will address this in greater detail I may address this in greater detail in the second part of our dialogue. There is the issue of the inspector for complaints against the Israel Security Agency interrogators. This function was previously resided within the Israel Security Agency. There were concerns raised with respect to the independence and impartiality, or at least the appearance of independence and impartiality. And this position has currently been moved to the Ministry of Justice and operates independently of the Israel Security Agency as of 2013. You have also raised issues with respect, or raised a question with respect to the Minerva project, which I think is an excellent project. It's an important example of cooperation between government and civil society and academia. I see great importance in the continuation of this project, and also in the substance of just the opportunity to exchange ideas with organizations, various organizations dealing with various human rights issues. Immediately when I was appointed, I invited the representatives of various organizations in the Israeli civil society to meetings, just in order to listen and hear what issues are on their agenda and what issues we could perhaps promote and address. And this project gives us an opportunity to do that. In addition, in this project, we try to provide a preliminary draft of the report that eventually is submitted to the committee or to the various human rights committee. In fact, this particular report that we're discussing today was the first time that we have done that, and I think it was beneficial. I think we should aspire to provide the report to the human rights organizations earlier, so that we can benefit from the comments and to a greater extent, but I certainly think that we are working in a good direction in this respect. One issue I would raise here, I was informed that the Minerva project has been sponsored by, in part by the European Union and other donors, and we're very grateful for this support. I was told that there may be some issues regarding the continued provision of financial support to this project, and I think it is very important to address this. I think it will be a shame if we cannot continue with this project. I'm certainly, as the government, we are committed to do what we can to continue with this, and to the extent that this committee can help us by recognizing the importance of this project, this will be greatly appreciated. I will now turn the floor to Ms. Orit Kremer from the Ministry of Foreign Affairs. Thank you very much.
Thank you. With regard to Israel's position on the implementation of the covenant, as the members of this esteemed committee are well aware, there has long been a debate about the applicability of the convention to the West Bank and the Gaza Strip. Israel does not refer to the implementation of the covenant in those areas for several reasons, ranging from legal considerations to the practical reality. In line with the basic principles of interpretation of a treaty law, and in accordance with the Article 29 of the Vienna Convention on the Law of Treaties, Israel consistently maintained that the Convention and other human rights instruments are territorially bound and do not apply and were not intended to apply to areas beyond the state's national territory. The relationship between the law of armed conflict, which applies also to belligerent occupation, and the law of human rights remains a subject of serious academic and practical debate. For its part, Israel recognizes that there is a profound connection between human rights and the law of armed conflict, and that there may well be a convergence between these two bodies of law in some respects. However, in the current state of international law and state practice worldwide, it is Israel's view that these two systems of law, codified in separate legal instruments, remain distinct and apply in different circumstances. Therefore, the Palestinian population is rather subject to the laws of armed conflict. In addition to those legal arguments, critical to assessing Israel's obligation pursuant to the Convention is the changing reality and the dramatic developments in the ground in the past few years. These include Israel's disengagement initiative in August 2005 involving the full withdrawal of all Israeli forces, the dismantling of its military administration, along with the evacuation of over 8,500 civilians from the Gaza Strip, and the rise of a Hamas-led terrorist administration committed to violence and the destruction of Israel. In these circumstances, Israel clearly does not have an effective control in Gaza, and in the sense envisaged by the Hague regulations, and the responsibility for the civilian in Gaza Strip is within the duties of the Hamas regime. In the West Bank, the practical reality is that due to the implementation of various agreements between Israel and the Palestinians, the vast majority of Palestinians, over 95%, fall under Palestinian and not Israeli jurisdiction. Thank you. I would like to pass the floor to my colleague, Liron Bar-Sadeh.
Thank you. I will refer to the questions asked about the people who entered Israel illegally across the Egyptian border from the Sinai Peninsula. In recent years, the State of Israel, like many other developed countries, mostly in Europe, but in also Australia and other places, have been experiencing.
The interpreters would like to ask the speaker to slow down kindly. Thank you.
Unlawfully by crossing the Israeli-Egyptian border, which since has been closed by a fence. The total number of such individuals who reside currently in Israel stand at more or less just about 47,200 individuals. And of them, about 9,200. Sorry, I will speak slowly. Of these 47,200 more or less individuals currently residing in Israel, more or less 9,200 of them are Sudanese, and just about 34,800 are Eritreans. These individuals residing currently in Israel are not forcibly, returned to their countries. Israel respects the principle of non-refoulement, and these individuals who remain in Israel, of them, just over 2,000 were at the beginning of October in the Cholot facility, which I will refer to in a few moments. These individuals have access to education. As I will mention that of these 47,000 more or less people, about 730 are minors, and they enjoy full education as any Israeli child in Israel. They have access to health facilities, and when needed, they have access also to other services as welfare or psychological amenities when needed. We do not exercise forcibly preventing them from work, and many of them have access to work, mostly in the tourist industry, as in restaurants or in hotels. The situation in Israel of this number, the sheer numbers and the range of issues raised currently from the presence of these individuals challenge the economic and social sectors of Israel. The situation in Israel is more complex than that of other developed countries, as Israel is the only developed country with a long land border with Africa, which makes it comparatively more accessible for those who wish to enter. Moreover, due to Israel's unique geostrategic situation and the current political instability surrounding its borders, it becomes practically impossible to develop regional cooperative solutions with countries and origin and transit as done by other developed countries who have the same issues of illegal immigrants. As to the principle of non-refoulement, Israel signed the convention relating to the status of refugees of 1951 and ratified it in 1954. The principle of non-refoulement enshrined in Article 33 of the Refugee Convention constitutes a fundamental principle of international law and was enshrined into Israeli case law 2 decades ago through the High Court of Justice ruling. The former president of the Supreme Court, Mr. Justice Aharon Barak, determined that the principle of non-refoulement, according to which a person cannot be deported to a place where where her or his life or liberty will be endangered, is not limited only to refugees. And Justice Barak held that the principle of non-refoulement is applicable to any government authority decision dealing with the deportation of a person from Israel. Israel tries to balance the need to control its borders with the need to protect the human rights of those who enter. Due to its adherence to international law, Israel granted protection at the time to approximately 60,000 people without the need to prove prima facie that they have an individual claim under international law to stay in Israel. Those individuals amount to approximately 95% of all individuals who entered Israel and who currently reside in Israel. The legislation that was annulled recently. In 2013, the Knesset adopted new legislation designed to amend 2011 legislation that was annulled by the Supreme Court. The purpose of the new legislation was to lower the financial incentive for migrants who enter Israel, while still granting protection for those in need in accordance with Israel's international legal obligations. Therefore, the law set out 2 measures: the limitation of the maximum detention period for any illegal migrant who crossed the border to 1 year, and the establishment of a new facility to accommodate illegal migrants who cross the border from Egypt. On September 22nd of this year, an extended 9-judges panel of the Israeli Supreme Court, sitting as a High Court of Justice, ruled on a petition brought forward by several NGOs and asylum seekers regarding the constitutionality of the 2013 legislation. The extended panel ruled by majority that holding persons for up to a year in detention constitutes a material violation of their human rights, including the rights to liberty and to the right to dignity. Therefore, the Supreme Court deemed the 2013 legislation unconstitutional and deemed Chapter 4 of the legislation, which had established the new Cholot facility, to be null and void. While the court did not rule out the right of the government to establish open facilities for migrants, it held that the Cholot facility is in its current incarnation does not meet the required constitution standards. This latest Supreme Court ruling is yet another example of Israel's justice system's commitment to upholding and defending human rights, even in the face of public pressure. In conclusion, I would say that we are still studying the ruling of the current ruling of the Supreme Court, which leans on principles of international law. And I thank you, and I now pass the floor to Mr. Newman.
Thank you. I will start with the question of one of the colleagues about the activities which are undertaken in the West Bank in order to promote and develop the planning in Area C of the West Bank. In this regard, I will say that the civil administration conducts various and continuous planning activities in order to promote and develop the planning in Area C. Over the last years, the civil administration of the area has made considerable progress in mapping clusters of illegal constructions and in drafting new master plans for these clusters. In addition, a comprehensive work has been done in the civil administration in order to determine the criteria for initiating planning projects to regulate the legal status of cluster or of illegal construction. In order to make this process as efficient as possible for Palestinian residents of the aforementioned clusters, in 2011, the civil administration hired a Palestinian company, ASIA, to design the master plans. In other instances, the civil administration coordinates with professionals from the Palestinian Authority on the matter of regulation dimensions above illegal clusters. Currently, a total of 16 master plans referring to such cluster of illegal Palestinian construction in Area C are underway at different stages of the planning process. 6 of these plans refer to clusters of the Bedouin population. A total of 3 master plans are already fully approved: Ras Atira Daba, Al-Ra'in, and Nizal. Another question was about the Bedouins residing in illegal villages east of Jerusalem. In this regard, I would say that the Bedouin tribes in area east of Jerusalem are semi-nomadic tribes who currently inhabit illegally in lands owned by the State of Israel, to which they have no territorial claims. These tribes currently reside in illegal structures and buildings that have not been approved by the civil administration. Some of the tribes, such as the Khan al-Ahmar, have received demolition notices for temporary structures that were constructed without building permits from the civil administration as required by the applicable law in the West Bank. In spite of the issuance of this demolition order, Israel's position, as was also articulated before the High Court of Justice in a petition submitted against the decision, is that it would not enforce the demolition order that were issued to the buildings at hand as long as it cannot offer an alternative solution for the Bedouin population. The plans for the development of Ramat, Noyama, and Ja'alin, if approved, will constitute such solutions. Throughout the deliberation, the Bedouin have clarified that they desire an improvement in their living conditions and for development. In order to facilitate these aspirations, the civil administration has drafted plans to accommodate them in an area in which, unlike their current situation, they would have greater accessibility to health, education, and other civil facilities and infrastructures. The new plans will enable the housing of several tribes in accordance with the law and at very low cost for the Bedouin population, with the aim of improving their well-being and making this improvement available to all, regardless of their socio-economic status. It is important to clarify that the plan regarding the residents of Khan al-Ahmar has not yet been approved but was only published in order to invite objections from the public in accordance with the standard approval procedure. If objections are made, a special committee shall discuss the objections, and only if the committee decides to approve the plan will it be carried out. Note that the state has conducted a number of consultations with the Bedouin attorney, including a recent consultation that was held in September 2014. Now I will refer to another question about the punitive demolition that was held in the West Bank in the past few months. Since 2013, Israel had been witness to an alarming increase in terrorist activities both on Israeli soil and in the West Bank, where over 1,400 terrorist incidents took place, endangering many Israeli civilians, starting from stone and Molotov cocktails thrown towards Israeli citizens and security forces, and ending with the murder of commanders Baruch Mizrahi by Hamas terrorist member Ziad Awad, and the abductions and murder of the 3 Israeli teenagers by 3 other Hamas members, Hussam Qassam, Amar Abu Akhia, and Marwan Qassam. Owing to the general deterioration in the stability of security situation in the West Bank, and especially in light of the atrocities, terror attacks that caused the deaths of the police commander Baruch Mizrahi and the 3 Israeli teenagers, the chief of the Central Command found it necessary to resume the use of house demolition and ordered that the preparators' residence shall be demolished subject to a formal hearing. It is important to emphasize that in light of the hearing set forth in front of the Chief of the Central Command, some of the demolition were condensed to a limited area of the residence. The preparators submitted petitions to the High Court of Justice, which were subsequently denied. The court reaffirmed its long-standing position on this issue and ruled that the prevailing circumstances in the West Bank presented a substantial risk to the security of Israel and its citizens, and therefore justified the resort to house demolition in the present cases. Consequently, 4 houses of the preparators were demolished. Some were fully demolished, while others were partially demolished or partly sealed off. I would like to emphasize that at present, the Israeli policy regarding the use of house demolitions for the purpose of deterrence remains the same, that is implementing the method only in exceptional circumstances, namely in light of the general security situation and possible terrorist waves and their severity. Now I will refer to the questions that were addressed about the water resources and the supply of water to the Palestinian population in the West Bank. The interim agreement includes detailed provisions relating to the management of water resources in the West Bank by the 2 sides. The agreement includes provisions on such issues as a cooperation between the sides in the field of water, the need to develop additional water infrastructure, such as desalination, and provisions relating to the allotment of water to both Israeli and the Palestinian Authority, established a joint water committee, JWC, whose role is, among others, the coordinated management of water resources. All decisions made by the JWC, including decisions relating to the drilling of wells or other related water projects in the West Bank, by both Israel and the PA, must be reached by consensus. Regrettably, in recent times, the Palestinian side declined to discuss any water and sewage-related projects in the West Bank that may contribute to the Israeli citizens in the West Bank. This approach has brought the JWC into a stall, as no projects are being currently promoted in it. In any case, Israel has met all its obligations according to the interim agreement in terms of the additional quantities of water to the Palestinians, and has indeed even exceeded its obligations. In practice, during 2010, Israel supplied the Palestinian Authority in the West Bank a total of 52.6 MCM, an addition of 21.7 MCM a year behind its obligation according to the interim agreement. This practice has been applied consistently by Israel, as every year since the 1995 interim agreement, Israel water supply to the Palestinians exceeded the amount agreed upon and grew gradually over the years. Now, regarding the questions about the activities against unapproved wells, I would like to say that since its establishment, the Joint Water Committee approved the drilling by the Palestinians in the West Bank of 57 new drinking water wells, 21 substitute wells for domestic use and for irrigation of agricultural lands, and 22 observation wells. Also approved was the upgrading of 42 wells in the vicinity of Kalkilia and Tulkarem, and 13 wells in the Jordan Valley. Out of the 100 wells that have been approved for drilling by the JWC, only 56 wells were actually drilled. In addition, since the signing of the agreement, more than 300 unauthorized wells have been drilled in the West Bank, in particular from the northern basin in the area of Jenin and from the western basin in the vicinity of Kalkilia and Tulkarem, from which the Palestinians are abstracting approximately 10 MCM a year. These illegal wells are drilled in violation of the interim agreement without the approval of the JWC. These unauthorized wells may ruin the shared aquifer and may cause an ecological disaster. The interim agreement states that the future needs will be supplied mainly from the eastern aquifer. However, the unapproved wells were drilled mostly in the northern aquifer and in areas A and B. This means that Israeli production in the northern valleys within Israel has been affected. Based on the water agreement, Israel has taken action through the civil administration and supervisory teams that were set up in accordance with it against the violation of the agreement. The Palestinians routinely state that the unapproved wells are affecting them as well and that they too are trying to combat the phenomena. However, in fact, no concrete action has been taken by them to stop the illegal drilling, which constitutes a serious violation of the water agreement. Now I will refer to the last issue about the administrative detentions and guarantees that are given to the individual which are arrested. The procedure for issuing orders for administrative detention includes several safeguards which guarantee the rights of the individual against both abuse and arbitration. First, prior to the issue of detention order, an independent military prosecutor provides a legal review through conducting an assessment of the information that the order is based upon. This assessment is legally binding on the military commander. Second, once a detention order has been issued, it is subject to a multi-layered system of judicial review by the military courts in the West Bank. These judicial institutions are impartial and functionally independent from the IDF chain of command, meaning that they exercise unfettered professional discretion. Military court judgments are binding on the military commanders and cannot be revoked, circumvented, or superseded by the authority, with the exception, of course, of Israel's Supreme Court sitting as the High Court of Justice. Upon the execution of the detention order, the detainee must be brought before a military district court judge who may either confirm the order or quash it in its entirety, or may also reduce the stipulated period of detention. The military courts are known for their active intervention in these cases and often shorten the detention period so as to hasten the time in which the military commander representatives will be required to appear before the military courts following a renewed detention order. Hearings in the military courts are conducted in Hebrew with simultaneous translation into Arabic. Detainees wishing to challenge the approval of a detention order by a military court may appeal to the Military Court of Appeals. Ultimately, the detainee may challenge the judgment of these courts by filing a petition with Israel's Supreme Court sitting as the High Court of Justice, which take a proactive approach regarding the examination of an administrative detention order. Regarding the questions of the right to legal representation and the notice to the family, I will update that the individual is being told when he is under custody about the administrative order and about his right to legal representation by an attorney of his choice. He can also update his family about the arrest. It is worth mentioning in this regard that currently there are no minors or women held under administrative detention in the West Bank. Thank you. I will now transfer the floor to my friend Asaf Retzinger.
Thank you. I would like to address several questions that related to the Bedouin population. Following the work of the advisory Goldberg Committee in May 2008, the implementation cadre completed the preparation of a government plan for regulation of the Bedouin housing situation in the Negev and submitted it to the government, also known as the Proverb Plan. The cadre final report mentioned 6 main principles for the operation of the national plan, among them planning and regulation of the Bedouin housing situation in the Negev as much as possible in its current location, subject to acceptable planning parameters, and economic efficiency, compensation solution agreed geared toward the settling of Bedouin lawsuits in legislation, and a limited schedule of 5 years. Following the Praver report, the government resolved to form a bill enacting the plan's implementation framework in the government resolution 3707. The government further decided that the bill formation will be carried out in consultation and cooperation with the Bedouin population. This listening stage included the collection of the population comments through meetings in writing and a special website established for this purpose. In order to provide full attention to the listening stage, the government appointed Minister Binyamin Ze'ev Begin as the head of this important stage. On January 27, 2013, the government approved Government Resolution number 5345, in which it adopted the report submitted by Minister Begin and approved the draft bill. In June 2013, the bill was approved by the Knesset in first reading. The above mentioned, the previously mentioned legislation and plans have encountered large-scale controversies among the Bedouin population, and the bill also raised the criticism and protest and is considered controversial by other populations. In 2013, Minister Begin announced that the retraction of the bill from the agenda inter alia due to the criticism and opposition to this bill. In January 2013, the minister appointed, 2014, the minister appointed Minister of Agriculture and Rural Development, Yair Shamir, to be in charge of the Bedouin housing situation on the Negev. On June 8, 2013, the government approved resolution number 1695, which established a ministerial committee on the Bedouin housing and socio-economic development of the Bedouin population, headed by the Prime Minister. The purpose of this establishment of this committee is to formulate the required policy and resources for the promotion of this issue. Moreover, the government decided to establish a committee of general government ministries, General Director, headed by the General Director of the Ministry of Agriculture, that will be in charge of implementing the ministerial committee's decision. As of September 2014, the Minister of Agriculture and Rural Development decided to review the bill that was retracted by former Minister Begin, and the legislation process was halted. Currently, alternatives to the law which will be enable to regularization of ownership claims are examined and formulated. Currently, solutions are given through the Israel Land Authorities Council resolution. In regard to services provided to the Bedouin population, in regard to health services, in the framework of Government Resolution number 3708 of September 2011, $24.3 million were allocated to the issue of society and community, which include the health field. Some of the main projects involve increasing the number of Bedouin mediators employed in the program for reducing infant mortality rate, continue research to map genetic diseases which are unique to the Bedouin population, enriching flour with folic acid for the benefit of pregnant women, establishing a healthcare center within large schools in the Bedouin population, and others. In regard to health clinic and medical center, as of October 2014, there are about 50 health clinics providing medical services for the Bedouin population, in addition to 10 independent physicians who work with these health funds and provide such services. The Israeli government recently issued a resolution to build 4 medical centers in the Bedouin diaspora, providing emergency medicine services during nights and weekends. When regular clinics are closed, these centers are expected to be opened during 2015. In regard to mother and child healthcare stations, there are 45 such stations located in the Southern District. 25 of which, more than 50%, serve the Bedouin population. In 2012, $1.2 million were allocated for the construction of 3 additional mother and child healthcare stations. Additional stations also serve the Bedouin population in the vicinity of these localities, as well as a mobile station. In regard to nurses serving the Bedouin population in the Southern District, there are 191 employed nurses. 103 of them serve the Bedouin population. The nurses are trained, among other things, on issues that are specifically important for the Bedouin population. In regard to immunization coverage, in 2012 figures show that the rate of immunization coverage regarding the Bedouin children is over 90%, similar to the general population. In regard to education services, in the frame of government resolution number 3708, designated 5-year plans for the years 2012 and 2016 were implemented in order to improve scholastic achievement and to reduce gaps among the pupils in the Bedouin population, with a total budget of $33.5 million. Among these programs, increasing the amount of literacy classes from kindergartens to high school, increasing the attendance of pupils, and reducing dropout rates. Operating project education toward career, recognizing and diagnosing learning impediments, expanding technological education, and education completion for detached youth and adults. Additionally, in accordance with Government Resolution number 3148 of April 2011, the establishment of the rehabilitation complex for the Bedouin children with special need in Tel Sheva still continues. So far, 2 special education schools and 2 clusters of kindergarten were established and are operating pursuant to the development plan. The construction of additional 4 classes for rehabilitation daycare centers will begin this year. Thank you. I now give the floor to my colleague Hilat Eni-Gilad.
Thank you. I will touch regarding several issues raised by Mr. Flinterman. Regarding the first protocol, Israel is routinely exploring the issue of joining the first protocol. To date, our position on this issue remains. As for the second protocol, although the State of Israel has to date only executed Adolf Eichmann in 1962 for his heinous crimes against the Jewish people during World War II, it still has several provisions allowing the death penalty in very extreme cases. Subsequently, Israel is not able to join the protocol at this time. Regarding the issue of reservations, to date, the issue of personal status remains in the hands of the religious communities in Israel. Thus, Israel's reservation to Article 23 of the Convention remains. I now give the floor to my colleague, Mrs. Marks.
Due to time restrictions, I'll briefly relate to 3 additional issues that arose. The first one, the review of legislation concerning the state of emergency. The State of Israel remains in an officially proclaimed state of emergency since 1948, following 4 days after its founding. Since then, the state of emergency has remained in force due to the ongoing state of war or violent conflict between Israel and its neighbors, and the constant attacks on the lives and property of its citizens. However, over the past 10 years, the Israeli authorities have been comprehensively reviewing all of the legislation that is connected to the existence of a declaration on the state of emergency in order to enable the cancellation of this declaration. In this framework, certain laws have been annulled or amended, and those laws that their continued validity was found to be necessary have been enacted as independent laws that are not conditioned by the state of emergency. In our periodic report, we made reference to the shipping laws that have recently been enacted, and to over 100 supervision orders enacted in accordance with the Supervision on the Produce and Services Law, which have been annulled. In addition, the Knesset is debating the Fight Against Terrorism bill with the purpose, eventually, upon its enactment, of annulling further legislation that rests on the declaration of the state of emergency. So too, for example, there's an interministerial committee which is debating work and rest hours with a similar purpose in mind. The court in 2012 rejected a petition brought by the Association of Civil Rights in Israel to cancel the declaration of the state of emergency, but it did so because it was of the opinion that the authorities should be allowed to continue and conclude the legislative activities which this important petition assisted in promoting. And the court noted too that the Israeli reality is still sensitive and very complex and does not allow leaving the authorities without the necessary powers that they require in times of emergency. Secondly, I'll relate to the question of equality, which indeed isn't mentioned explicitly in the basic laws. However, I want to stress that it is a most basic principle of Israeli jurisprudence. At a very early stage, the Supreme Court recognized that the principle of equality is an integral part of the human dignity and granted it constitutional status as an inherent part of the basic law, human dignity and liberty. This stems from seminal judgments given very shortly after the enactment of the basic laws. As a consequence, all of the legislation that was mentioned in the question, as with all other legislation, is subject to judicial review in accordance with this basic principle. Some of the judicial review of the laws that were mentioned has been completed, some are still pending, but all give serious consideration to the principle of equality as a basic constitutional principle. Lastly, mention was made of self-expressions of employees within the work environment under the Operation Protective Edge. And we are aware that there were some instances of sanctions that were imposed on employees within their work environment following different expressions of their political views. In such cases, the Equal Employment Opportunities Commission in the Ministry of Economy intervened, examined these cases and tried to resolve them in cooperation with the employers. In some cases, it managed to do so and to revoke the decision and to allow the employee to resume his or her previous position. And it also provided an important service of giving legal advice to employees that had experienced difficulties in this kind of circumstances. Thank you.
That completes the first round.
Thank you. Immaculate timing for the whole delegation, especially the final speaker. Thank you very much, Ambassador. We'll go into follow-up questions and the second round, which I'll fold together after the lunch. We meet again at 3 o'clock. Meanwhile, I wish everybody a good lunch. The session's adjourned.